What up, what up, what up? It's your favorite shit talking squirrel back from the YouTube video. So today we have a follow-up on a hearing I covered a few weeks ago. I'm gonna leave a link to the original video in the description, and there's a tag popping up on screen right now. But I recommend if you haven't seen the first part to stop, go watch that, and then come back. Now, assuming you've seen that, this really wasn't as much a hearing as it was a trial. It was really long. It was like over 8 hours of footage. So I'll just be covering the highlights today just to kind of bring this case to finality. So keep in mind, I did the best I could to kind of trim down 8 hours of footage into a 1 hour, highlights video. So with that in mind, hope you enjoy and let's get this.
Good morning, everyone. We're about to go on the record. We're continuing the matter, complicated matter of Rosemary Blair versus Joseph O'Donnell and Carla Bowers. It's had quite a procedural slog through the system, been adjourned several times, continued several times. I've blocked out the entire day today for the matter. We have two new attorneys that will be appearing here, Robert Soltis for Rosemary Blair, and Jennifer Wu will be appearing for Mark Verpalat, one of the third-party defendants. Anyway, good morning, everyone. Let me get started here. For my Rutgers friend, I finished in second place at the end of the Learned League season. I think I'm in like a remedial division, but it's the highest I ever was. All right, let's go on the official record. This matter is entitled Rosemary Blair versus Joseph O'Donnell and Carla Bowers. The file number is 221862. There are three third-party defendants, Mark Verpalat, Patrick Blair, and Karen Stiver. Attorney Daniel Hatch is here on behalf of Joseph O'Donnell and Carla Bowers. Mr. Soltis, why don't you go ahead and put your appearance on the record?
Thank you, Your Honor. Robert A. Soltis on behalf of Rosemary Blair. Ms. Blair is right to my left.
Good morning, Ms. Blair.
Good morning.
Mr. Hatch, why don't you go ahead and place your appearance on there as well?
Good morning, Your Honor. Dan Hatch on behalf of defendant counter plaintiffs Joe O'Donnell and Carla Bowers,
Who are both present also. We have a new participant here. Attorney Wu, would you come up and place your appearance on the record as well? Come up to the podium if you would.
Sorry.
Just come to the podium there so you'll be on camera.
Oh, lovely. Jennifer Wu of the law firm Lewis, Reed & Allen on behalf of third-party defendant Mark Verpalat.
Thank you very much.
Thank you
for being here. Mr. Soltis, who appears before this court quite often in landlord-tenant matters, has filed an appearance on behalf of Ms. Blair, and he's challenging the jurisdiction of the court to determine the damage question, and that it's over $25,000. Normally, the district court does not have equitable jurisdiction, but in some landlord-tenant cases, there is some equitable jurisdiction. And in this case, by default, I have ordered specific performance that she comply with the terms of the original lease, option to buy, or land contract, or whatever we're going to call it. So they've asked for specific performance. We want to buy this house at the agreed upon price, and that's been ordered. We haven't nailed the terms down, but that's in the pleadings. It was subject to the default. It was not set aside. So where does that leave us? Let's start first with the entry of the order. Mr. Hatch, you submitted the order as I directed. And it states that the motion to set aside the default was denied for the reasons stated on the record, which I've restated here. Do you wish to speak to that any further?
I do, Your Honor. Thank you, Your Honor. Dan Hatch on behalf of Joe O'Donnell, Carla Bowers, and may it please the court.
If this guy gets up there and says, based on what law, in fact, I'm going to completely fall out of my chair laughing.
You're right. The May 26th order, I drafted it. I submitted it under the 7-day rule. A couple things. Number one, Mr. Hauser was terminated as Ms. Blair's counsel on May 26th in front of this court. He withdrew his counsel. He no longer represents Ms. Blair. The court denied the motion to set aside the defaults because it found, as we briefed, that there was no meritorious defense and no good cause to set aside the defaults. So I offered to submit an order. I submitted an order under the 7-day rule. It stated that the motion was denied for the reasons stated on the record. And I put with prejudice, as I do on most motions, because you can't just bring the same motion over. And there's a way that you can seek relief from the court. It's called the motion for reconsideration. You can't just file another motion because you hire a new attorney and now you want to try to bring it again. So that's why I put in the order it's denied with prejudice, which it was. Ms. Blair, Mr. Soltis could file a motion for reconsideration, which they have not done so far. So number one, the order is accurate. And number two, it's precarious that Mr. Hauser would be filing an objection when he doesn't represent Ms. Blair. He was relieved of his duties to represent Ms. Blair. He still is counsel of record for Karen Stiver and Patrick Blair. He has no standing to object to an order that has nothing to do with his clients, who are Karen Stiver and Mark Verplat. So for the reasons that the order is accurate and the fact that Mr. Hauser doesn't have any standing, we would ask that the court enter the order as it was submitted. Thank you.
Mr. Soltis, do you have any comment regarding that?
Yes, Your Honor. A couple things. If the court is ordering that order that was presented be entered, the time for reconsideration hasn't even begun, never mind passed. So that's still open. I've gone and looked at the tapes that we were made of the hearings in the past. I don't believe the court said with prejudice or without prejudice. So what my request is, Judge, just strike out that last language and let the order accurately state what you did. You denied the motion.
And I didn't state it, so that is what I'm going to do. I'm just going to take that out. Counsel's right. You can't just refile the same motion over and over again, but there is a way to do it. So I've stricken the last two words with prejudice and I've signed the order. Somehow it's got a 220. So the date of the order is today, 6/28/23. Denying the motion to set aside the default. It has the same effect. That order remains, including the order for specific performance. All right, the next issue is regarding the contempt of the defendant, Rosemary Blair. Mr. Hatch was quite vocal in his objections. He was here. I don't think they ended up bringing all their everything they needed, but he was here prepared to do the deposition. She was told on the record she was to be here. There was an order denying her request to not come, and she did not come. So we're here for today's hearing. Mr. Hatch has not had an opportunity to depose Miss Blair. She wanted to tell her side of the story. And she said, when do I get my turn? And I said, well, I'll get the turn at the deposition and at a later hearing. So this record was made without counsel being here, without the defendant being here, and I didn't make any finding. So at risk of having you say everything all over again, What's your position regarding the contempt of the plaintiff Rosemary Blair?
Thank you, Your Honor. I won't rehash everything that we talked about on the 16th already, but the motion for direct contempt was entered by the court on June 16th. So as I stated, we've got various sanctions and relief that were requested in the motion. Some of those are moot at this point, but at this time, we are asking for two forms of relief for the direct contempt. So under MCL 600.1721, following the finding of civil contempt, the court may order any or all of the following sanctions: a fine of not more than $7,500, a coercive conditional jail sentence to compel the party in contempt to comply with the order. I understand the court has denied that. And if applicable, damages for loss or injury caused by the contempt conduct. So it's up to the court to decide whether they want to impose a fine. We would be asking under MCL 600.1721 for damages for loss or injury caused by the contempt conduct. Those damages are, as we state in our motion, $6,500 that we incurred, and that's not the total expense, but I think that is a reasonable expense for Ms. Blair failing to show up for her deposition twice. She failed to show up for her deposition on May 16th, and she failed to show up for her deposition in direct contempt of this court's order on June 16th. So I prepared for Ms. Blair's deposition twice. I drove to Mr. Hauser's office. Here is the deposition exhibit book with all the exhibits that I was going to go through with Ms. Blair. It was going to last all day, 7 hours. I spent a significant amount of time preparing for a deposition of a critical witness in this case. So it's not like something I was just going to do in 2 or 3 hours. I spent a lot of time preparing twice for a deposition. So at my rate of $395 an hour, which is reasonable under the per group factors and under the State Bar of Michigan State Law and Economic Digest, it's 16 hours, which would be very reasonable for my travel time from Grand Rapids to Kalamazoo to Mr. Hauser's office, which Ms. Blair didn't show up to, and from Grand Rapids to the courts, which Ms. Blair didn't show up to, in addition to the preparation for the deposition twice. So those are the money sanctions we're asking for. Also, as a sanction for her failure to comply with discovery, MCR 2.313, which is failure to permit discovery sanctions, under section MCR 2.313 B2 subsection B. If a party or an officer, director, or managing agent of a party, or a person designated under MCR 2.306 to testify on behalf of a party fails to obey an order to provide or permit discovery, including an order entered by the court under subrule A, the court in which the action is pending may order such sanctions that are just, including but not limited to the following. So subsection 2 has been met. Ms. Blair failed to appear for a deposition and permit discovery twice. Subsection B states, an order refusing to allow the disobedient party to support or oppose designated claims or defenses, or prohibiting the party from introducing designated matters into evidence. So in addition to the monetary sanctions, we are asking for the sanction to prohibit Ms. Blair from supporting or opposing our claims today for damages. And that's probably the next issue we're going to get into, which is what are the claims and what damages are going to be presenting. But that is the sanction we're asking. There's no trial by ambush. I have the opportunity to depose Ms. Blair before the trial. If she wanted to tell her story, she should have come to the deposition twice. It's not fair for her to duck out in a deposition and then try to hoodwink us at trial by going up and testifying when I haven't had an opportunity to depose her. If that was the rule, no party would ever show up for a deposition. They would just trial by ambush every single time. So there's reasons for depositions. Ms. Blair chose not to show up for a deposition, and there's a court rule specifically stating that if the disobedient party fails to permit discovery, i.e. a deposition, that the court can prevent her from supporting or opposing the designated claims. That's directly on point and what we're asking here for today.
Man, he is making a damn good argument. Like, everything he just said makes total sense, but still, like, I don't know, not giving her the right to say her 2 cents, like, speak on her own behalf, whether it be through her counsel or otherwise, just, yeesh, I have a hard time with that one. Like, there's the age-old saying, like, everybody has their day in court. I don't know. Let's see what Middleton says about this.
So $6,500 of our expenses incurred for the direct contempt, and that also prevent Ms. Blair from testifying, opposing our claims, or admitting any evidence in this hearing or any subsequent hearings in this matter. Thank you, Your Honor.
Mr. Soltis?
Yes, Your Honor. Ms. Blair informed the court that she couldn't be here because of a doctor's appointment. And that information, according to the Register of Actions, was transmitted to Mr. Hatch before the death. So, and then my understanding is he came down here and he was down here anyway. He said to the court, yeah, I'm down here anyway, so, let me take care of that. Well, Your Honor, first of all, if he drove to Hauser's office, I don't know that. I've not seen any bill of cost here or anything like that. So I don't have that information, so I can't respond to how much time and whether or not that's reasonable. If I had it, I could, but I don't. Second of all, Your Honor, when he says he has to prep twice, I don't think I would do that, and I don't think that's reasonable.
I can identify. I've had this file out 15 times and I get all ready to go. And one day we got tornadoed. It was nobody's fault. And I had everything, spent 2 days going over everything, was ready to go. And the tornado never came, but they shut the courthouse down. So we had to move it. Then I had to do it all over again. Then we were here on the 20th, in the date in May, and I prepared everything. And Mr. Hauser was removed, and so we didn't do anything. So I had to prepare all over again. So I can identify with having to get ready over and over again. My memory isn't what it was when I was 25. And so I have to reacquaint myself every time I have to dive back into this big, thick file.
Well, I understand that completely, Your Honor. However, Mr. Hatch claims that he's got a big old binder here, which means he prepared. And for him to go through that all over again, I think would either take a very little time, if he's even going to go there. I normally write down my questions before a deposition. And, oh, by the way, if I have to take the deposition later on, I look at my questions, they're already there. So it's not a chance where he has to go through the whole amount of evidence that you had to go through, but just whatever he wanted to ask of Ms. Blair. And Your Honor, there was no trial, and right now there is no trial. So I think the sanctions, yeah, there should be some money sanctions against Ms. Blair. $6,500, I can't tell you whether that's good or bad or indifferent, but I do think it's maybe a little, maybe high. I think Ms. Blair should be able to question the damages and present evidence that, the evidence is not correct. One of the issues in this case that I know the court has mentioned before is how much money was given to Ms. Blair for representing the down payment, if you would, on the lease option. It's not a land contract, the lease option. And, that is probably going to end up being determined by the circuit court. I've talked to Mr. Hatch, and I think we both are in agreement. He can disagree with me if he wants, that because of the fact that the court doesn't have the jurisdiction over 25,000, that if the damages here go over 25,000, that's got to go up to circuit too. And I know it's not the ideal resolution because I know the court doesn't want to send this up to the circuit court because, yeah, it'll take a bit. But on the other hand, if it goes over 25,000 and Ms. Blair is required to appeal, that's going to take even longer. And, you know, I don't think I think the only solution is to send this to circuit court. As for the deposition.
Well, why don't you go ahead? You sort of segued into your motion regarding jurisdiction. And why don't you address that further?
Your Honor, if I could just, before we segue into the jurisdictional issue, if I could just make a couple comments about the cost.
Yes. Stop. I'm ordering $6,500 in costs.
Okay.
She explicitly did not have my permission to not appear. I told her to be here. I did an order that said she didn't have the right to be here. I think it was a pretext that she was trying not to come. So you prevail. I'm not ordering 7 days jail or a $7,500 fine or the other things you asked for. However, I'm ordering your costs. So you may do an order that Rosemary Blair, as a sanction for contempt, shall pay $6,500. All right. Again, I stated my position on this. Maybe in hindsight, I should have just sent it upstairs right from the start. But I was hopeful I could get this case over the finish line. Mr. Soltis has come into the case on very late notice. And he went right to the pink elephant in the room regarding the jurisdiction of this court to hear the damage claim.
We would stipulate to bifurcate this case as to certain claims that exceed the jurisdictional threshold of the district court. The claims in this case are count 1, breach of contract, count 2, specific performance, count 3, violation of the anti-lockout statute, count 4, tortious interference, count 5, summary proceeding, count 6, quiet title, count 7, civil conspiracy, count 8, common law conversion, count 9, statutory conversion, count 10, trespass, and count 11, claim and delivery. So I believe the court was.
Where was specific performance in there under breach of contract?
That is count 2. It's right after breach of contract.
All right.
MCR 4.002, which I think the court was referencing, states if a defendant asserts a counterclaim or cross-claim seeking relief on an amount or nature beyond the jurisdiction or power of the district court in which the action is pending, the court shall either order the action transferred to the circuit court to which the appeal action would ordinarily lie, or inform the defendant the transfer will not be ordered without motion and notice to the other parties. So I think that's where you start out. But you have to specifically look to MCR 4.201. Subsection A states under removal, a summary proceeding action need not be removed from the court in which it is filed because an equitable defense or counterclaim is interposed. Subsection B, if a money claim or counterclaim exceeding the court's jurisdiction is introduced, the court, on motion of either party or on its own initiative, shall order in accordance with the procedures in MCR 4.002, which is the original one we just went over, removal of that portion of the action to the circuit court if the money claim or counterclaim is sufficiently shown to exceed the court's jurisdictional limit. So Ms. Blair has asked that the court just kick it all up to the circuit court. It's not how it works. So we would agree to bifurcate this case, the claims in this case with respect to count 1 breach of contracts because the damages do exceed $25,000. Count 3 violation of the anti-lockout statute over $25,000. Count 4 tortious interference. Count 7 civil conspiracy. Count 8 conversion. Count 9 statutory conversion. Count 10 trespass. Count 11 claim and delivery. We want to do that for a couple reasons. Number one, we want to make sure that this case is appeal proof. And also we want to make sure that if we're in district court for our money damages claim, we're capped at $25,000. We don't want that.
Well, or if I granted more, certainly it'd be subject to appeal and
Yeah.
nobody wants to do this twice.
Right. So those are the money damages claims. So we will stipulate under MCR 4.201, and I've had conversations with both opposing counsel before today, that will stipulate to count 1, count 3, count 4, and count 7 through 11. The court does not have to and should not kick up the claim for specific performance, summary proceeding, and quiet title. This court has jurisdiction under those claims. Specific performance is an equitable claim. It's attached to a breach of contract claim, but we're asking for equitable relief in the form that hopefully we'll be presenting here today. Summary proceedings, again, the district court has exclusive jurisdiction over, and also quiet title.
This is going to take us all day, but that's why we blocked out the day. I'm going to allow you to present evidence regarding the amount that you contend your clients have paid, either in direct lump sum or in monthly payments. And Ms. Blair is precluded from testifying in opposition to that because she didn't show up for a deposition twice. So I'm going to take your evidence essentially unchallenged. He can certainly cross-examine and argue about it, but you're right. If you could fail to appear for a deposition, then show up at the trial and give your testimony. What's the point of compelling a deposition? You just duck it by not appearing. So you can't have it both ways. So we're going to take a recess. I will, Ms. Wu, I would ask you to prepare an order removing Mark Verpalat's case to the circuit court. I will do an order. Mr. Hauser is still actually counsel of record for Patrick Blair and Karen Stiver, but I will do an order removing those matters also to circuit court. So the third party claims all have to do with money damages, and they'll be in circuit court. I will accept defendant's offer to remove all of the money claims to circuit court. And Mr. Hatch, I'd ask you to do an order to that effect.
Certainly are.
And we're going to address the 3 non-money aspects of the complaint: summary proceedings, specific performance, and breach. Oh, what's the third one?
Quiet title.
Quiet title, yeah, obviously it goes with that. So we'll take a recess, we'll come back, and we will start with that.
Your Honor, if I may, before we call witnesses, just a brief opening statement.
Yes, thank you.
Your Honor, this hearing is about green lights. So the first question that you probably have is, what do green lights have to do with this case? In life, green lights mean go, carry on, advance, continue. On the road, green lights are set up to give the flow of traffic the right of way. And when scheduled properly, more vehicles catch more green lights in succession. Green lights say proceed. In trial, green lights are affirmations of the truth. They're proof, support, praise, gifts, gas in the fire, attaboys, and appetites. They're cash money. See, we love green lights. They don't interfere with our direction. They're easy like a shoeless summer. Green lights say go and give us what we deserve. Now, green lights are earned, they're not given. And the purposes of today's hearing, we are going to prove by a preponderance of the evidence the relief that Joe O'Donnell and Carla Bowers are entitled to as part of this lawsuit through green lights. Before we get into proofs, I want to briefly discuss the remedies that we're asking the court to award here today, specifically the equitable remedies of specific performance and quiet title. In America, we don't believe in eye for eye justice. We're not here today to lock Ms. Blair out of her house and steal her personal property like she did to my clients. But while we don't believe in eye for eye justice, we also don't believe in saying tough luck or turning a blind eye when someone inflicts serious harms on another's life, like what happened here in this case. The American judicial system believes in accountability and consequences. And in civil disputes, our courts impose accountability and consequences through two primary vehicles: money damages and equitable relief. The equitable relief that we are asking the district court to award in this case is what is necessary to restore Joe O'Donnell and Carla Bowers to the position they would have been if Ms. Blair had not breached the land contract and had not illegally evicted them from the property. Specifically, at the close of our proofs, we will request that the court enter a judgment in favor of Joe O'Donnell and Carla Bowers against counter-defendant Rosemary Blair, ordering that Ms. Blair to perform her obligations under the land contract. Enter an order requiring Rosemary Blair to execute all the documents and instruments necessary to sell and transfer the real property located at 11247 Lakeshore Drive in Three Rivers, Michigan, in fee simple absolute to Joe O'Donnell and Carla Bowers, free and clear of any liens and encumbrances after the parties close on the sale of the property. And enter award requiring the purchase price remaining under the land contract to be set off by the amount of damages that Joe O'Donnell and Carla Bowers are awarded against Rosemary Blair in the circuit court. So the story of this case is best explained through a timeline, which I have as a demonstrative over to my right. Is it okay, Your Honor, if I step away from the microphone and move towards the demonstrative?
Yes. Go ahead.
Your Honor, the evidence in this case will show, and we're starting on the left of the timeline, that in June of 2021, Joe O'Donnell and Rosemary Blair entered into a lease agreement with an option to purchase. That lease agreement was temporary, and it was on a single page piece of paper that Ms. Blair drafted until the parties agreed to a further agreement. On June 11th of 2021, Mr. O'Donnell paid Ms. Blair two payments: a wire of $24,500 and a cash payment of $15,500.
Just a minute. Let's lock it on that for a minute, Laura, on the left lawyer camera channel.
You got it locked.
All right,
Okay, good.
go ahead.
My left side's my bad side, so it's okay.
My front side is my bad.
I got a
side.
face for radio. So on June 11th, there was the evidence will show that a payment was made between Mr. O'Donnell and Ms. Blair, $24,500 wire, and a cash payment of $15,500, totaling $40,000. At or around that time, Mr. O'Donnell, Ms. Bowers, and their 5 children moved into the house. They made subsequent cash payments after that. July 8th, $9,000 cash. There'll be evidence to that effect.
Right, stop, slow down. All right,
July 6th, a $7,000 cash payment from Mr. O'Donnell to Ms. Blair. There'll be evidence to that effect. July 22nd, a $4,000 cash payment from Mr. O'Donnell to Ms. Blair. July 27th, a $10,000 cash payment from Mr. O'Donnell to Ms. Blair. July 27th, a $500 cash payment from Mr. O'Donnell to Ms. Blair. The evidence will show that all of these payments were made towards the purchase price of the lake house. Now we fast forward until November 15th of 2021. That is when Rosemary Blair, Joe O'Donnell, and Carla Bowers executed the more full and formalized lease with an option to purchase, which is commonly understood as a land contract. November 15th, that date, Ms. Blair received a $600 cash payment, on November 12th, a couple of days before they signed the land contract, she received a $600 cash payment from Mr. O'Donnell. There'll be evidence to that effect. On November 15th, she received a $14,400 cash payment from Mr. O'Donnell. That is the infamous picture over here with the $14,400 of cash payments that Ms. Blair received on November 15th at her house in Crown Point, Indiana, from Joe O'Donnell, and Carla Bowers was present as well. That is the same contract that was signed on the same day that Ms. Blair now claims in this case that she did not have capacity to sign. Ms. Blair, there's no comments from anyone during.
Okay,
this day,
counsel.
So,
Let me do this.
well,
And let me do this. Just a minute. Ms. Blair, I know you've got strong feelings about this and you're listening through the headphones, so you can't hear anything, but hold your comments. You can share them with your lawyer, but don't say anything that be picked up.
I'm
by the-
sorry, I can't hear.
Yes, so, but don't say anything.
I won't say
Okay.
anything.
All right, very
I
good.
apologize, Your Honor. I should have asked the court to instruct and admonish the party not to speak during a written statement. So
Objection, whether it's
November 15th of 2021, the date that Ms. Blair claims that she didn't have capacity to sign, but she had capacity to receive $14,400 in cash, count the money, and it's sitting conveniently right on top of that land contract. She said she didn't have capacity to sign. So from January 31st of 2022, the next month, up until August of 2022, everything was fine. Joe and Carla in January of 2022 made a $14,500 cash payment to Ms. Blair. The evidence will reflect that. And now the monthly installment payments were made of $2,000 that the court previously heard testimony about. Under the land contract, they weren't required to make any payments. You'll hear testimony here today that Ms. Blair was strapped for cash, in her own words. So they went above and beyond to try to help Ms. Blair out to make installed payments of $2,000 to be offset.
Starting what month?
Starting on February of 2022 and continuing to June of 2022. So $2,000 in February, $2,000 in March, $2,000 in April, $2,000 in May, and actually $2,500 in June of 2022. Two separate payments. One was $500 cash, one was $2,000 cash. I'm sorry, there was another payment made in July. So from February of 2022 to July of 2022, there was $2,000 cash payments, 1 month, $2,500. Everything changed in August of 2022. This is the time that under the land contract, it reads that Ms. Blair, when she wanted to close or consummate the sale of the transaction, she would give Joe and Carla notice. And then within 90 days of that notice, they would close and pay the remaining balance of the land contract. You'll hear evidence today that Ms. Blair sent a text message to Joe O'Donnell on August 4th of 2022, stating that she wanted to close on the transaction. You also hear evidence that Mr. O'Donnell responded and said, let's move forward with the transaction, and was ready, willing, and able to close within 90 days and was working towards securing financing. This is the point in time when everything went wild. At that point in time, Ms. Blair got seller's remorse. She was confronted with the issue that she was actually going to have to part ways with this property.
I'm going to object, Your Honor. This is speculation and it's not relevant to the amount of damages.
Your Honor, it's a demonstrative, it's opening statement, it's not used for the truth of the matter. It's just.
It's, all right, I'll allow it, but yeah, it isn't. I'll allow it.
So circumstantial evidence between August 4th and what happens on August 12th of 2022. Ms. Blair sends the text on August 4th saying, let's close on the sale of the property. She hears back from Mr. O'Donnell. We're moving forward with the sale. She understands that within 90 days, she's going to have to depart with the property. On August 12th, Ms. Blair has her own property condemned. Davies Township comes out. They condemn the property based on what was first a fallen tree in the backyard and what was next some bottle jacks, your evidence under the foundation of the house that my client had no idea that were there.
Your Honor, may I have a continuing objection to this form of opening because it's not going to be
relevant to the amount.
and it's also not going to be followed up by evidence. So go ahead.
Some of this I'm aware of because of earlier arguments, and I also handled the condemnation case or that zoning hearing, not realizing until later that we were dealing with the same thing, and not realizing that there were tenants in the property. But I am aware from evidence that I heard regarding the events of August 12th. I've seen all the photographic evidence, the bottle jacks, the minor damage to the deck. And in fact, so it doesn't go to damages, but it may go to why we are where we are. So I will allow your continuing objection.
Thank you.
Thank you, Your Honor. And it is relevant to our claim for specific performance because under the factors under specific performance, we need to, number one, establish that there was a valid contract. Number two, establish that my clients complied with their obligations under the contract. And number three, establish that Ms. Blair breached the contract. So certainly the condemnation, the self-inflicted condemnation of the property and the eventual termination goes to an element of specific performance. So between August 4th, which was the 90-day text for the closing, and August 12th, the evidence will show that Ms. Blair had her property condemned, which is undisputed at this point as the court has handled that condemnation proceeding. And what happened after the property was condemned? My clients were removed from the property. And at that point, Ms. Blair could circumvent the summary proceeding process. She had them out of the property. So after August 12th, what happens? You'll see a letter from an attorney that Ms. Blair hired from the east side of the state of Detroit, Mr. Robert Yonker, that sent them a termination letter saying, relying on the condemnation term of the contract, saying the property has been condemned. And now under the land contract, which Ms. Blair claims that she didn't have capacity to sign, now the land contract is terminated and you must vacate the property. So she had her own property condemned, and then she relied on her self-inflicted condemnation to wrongfully terminate the land contracts in September. Then what happens? In October, after she has her own property condemned, Ms. Blair resorts to self-help and changes the locks on her own property in violation of the anti-lockout statute. I understand that that claim has been removed to the circuit court, but again, that goes to the breach of the land contract. She unlawfully removed my clients from the property and then locked them out, which is a breach of the land contract. In November, Mr. Yonker sends another threatening letter to my clients, now claiming that they've abandoned the property, which is curious because they were trying to get back into the property when they were locked out. And also Ms. Blair had filed a for recovery of possession. So my clients never abandoned the property, and that's why we're here today, because they want the properties back. And then December of 2022, Ms. Blair files the summary proceeding lawsuit to regain possession of the property that she already wrongfully evicted the clients from. So that's the story. That's the picture of the case.
Man, this is unbelievable. This was so much worse than I initially suspected. So, just to recap really quick, this lady sells the couple the house, and we won't have time to get into all of it, but she demands they pay for the house in cash payments because, according to her, she has family that are coming after her financially and doesn't want them getting at the money. She doesn't want a paper trail, basically. Why that wasn't a red flag to the buyers at the onset, I don't know, but regardless, the couple, I think, susses out that something ain't right here, and they have a contract drawn up. I don't know. Again, like, why would you start making payments on a house without a contract? But whatever. So the slumlord then claims she wasn't of sound mind to sign said contract, and has the house condemned on bogus accusations of a fallen tree and something about bottle jacks in the foundation. I don't even know exactly what that is, but whatever. She then changes the locks, sues the couple for her house back, and claims she never received the money. So she basically stole all the money from this poor couple and tried to sue to get her house back. And when she was inevitably countersued by the couple, She played the lawyer hopping game to get continuances and is now delaying things even further with this jurisdictional nonsense. Man, this whole I'm just an old woman and I don't know what's going on. It's absolutely capped. She is full of shit. She's 1000% manipulating and deceitful and just playing every card she can to try and get one over on these poor people. And it is too sweet that Judge Middleton is here to put a stop to it. So the next 6 hours or so is basically testimony from the husband about payments he made in cash and whether or not she was of sound mind during the contract signing. So let's hear closing arguments from counsel, and then we'll hear Judge Middleton's decision.
In June of 2021, Joe O'Donnell and Carla Bowers moved into the lakefront property at 11247 Lakeshore Drive with their 5 children to live the American dream as a single nuclear family. Over the past 2 years, Rosemary Blair has done everything in her power to turn that dream into a nightmare and ruin their lives. Today, on June 28th of 2023, almost 2 years to the day after they first moved into the property, we ask that the court give Joe, Carla, and their family their lives back by holding Ms. Blair accountable for her actions. First and foremost, I want to sincerely thank the court for its attention and listening to the testimony here today, and on a broader scale for its patience in dealing with this case over the past 6 months. Closing argument is not the time to rehash everything that has occurred before trial, but I think the court would agree with me that this case has turned into something that it should have never been. Ms. Blair could have entirely resolved this dispute by owning up to the mistake that she made when she unlawfully kicked Joe, Carla, and their children out of the property in August of 2022. Had she simply let my clients back into the property and moved forward with the sale of the house, none of us would be here today. Joe and Carla's life together would have never been uprooted. Their relationship would have never been plagued with stress and mistrust. And most importantly, they would have never had to explain to their children why they lost their home. But that resolution would have required Ms. Blair to do something that she has shown time and time again that she is incapable of doing: playing by the rules and admitting that she was wrong. As the undisputed evidence is shown here today, Joe and Carla entered into a valid and enforceable contract with Ms. Blair to buy the property at 11247 Lakeshore Drive. Between June of 2021 and July of 2022, Joe and Carla paid Ms. Blair a total of $112,000 towards the $450,000 purchase price of the property. Then in August of 2022, when Ms. Blair indicated she wanted to close on the sale of the property and collect the remainder of the purchase price, Joe and Carla worked to secure financing and were ready, willing, and able to consummate the sale of the property within 90 days. But everything changed in August of 2022. At that time, Ms. Blair turned into, quite frankly, a bad decision-making factory. She got seller's remorse when she was confronted with the reality that she was going to have to part ways with the property that she owned forever. To get out of the land contracts Ms. Blair executed with Joe and Carla, she had her own property condemned and then turned around and attempted to use that condemnation as a means to terminate the land contract, the lease with option of purchase. She then hired a lawyer to send threatening letters to Joe and Carla demanding that they vacate the property. And at the same time, she took matters into her own hands by unlawfully locking them out of the property. And after she locked Joe and Carla out of their home, she stole countless items of their personal property, including boats, beach chairs, rafts, grills, coolers, speakers, life jackets, and even a snowmobile and snowmobile. Miss Blair is a deeply troubled person, violently unafraid that there are consequences for her actions. And in her relationship with Joe and Carla, she was downright cruel. She has lied to the court countless times, claiming that she was only paid $30,000 towards the purchase of her home. She apparently forgot about the other $82,000 of cash that she was paid by Joe and Carla when she was, in her own words, desperate for cash. She has also come up with ridiculous positions that bear no semblance to the truth, such as her claim that she lacked the mental capacity to execute the lease with the option of purchase, which is the same lease with the option of purchase that she relied on to kick Joe and Carla out of the property. What Miss Blair did in this case was an act of profound cruelty. not just to Joe and Carla, but also to their children. Thankfully, the court can provide a remedy for that wrong that have been inflicted upon Joe and Carla through its equitable powers of the grant of specific performance.
Mr. Soltis, you've been doing a remarkable job considering how short of a time you've been in this complicated case. What are your thoughts on the matter?
Well, Your Honor, I generally agree with you. How about that? There's three counts that haven't been brought up to circuit. One is the summary possession. I think the court has already addressed that. And if not, then I will stipulate that Mr. O'Donnell and Miss Bauer can stay in the house until there is either a court order saying otherwise, or they don't exercise the option. So I don't think that really needs to be litigated.
All right.
The other aspect is quiet title. Quiet title, obviously, Your Honor, I don't think can be addressed until we know if they are going to exercise their option. And right now, that's still up in the air. So I think it would be premature. Now, with regard to specific performance, that's the key, I think, today. And I think this court can order that Miss Blair follow the agreement. So if the O'Donnell and Bowers tender the 300 and you say 334,000. I don't think they've proved all of that, but you're the judge. That she should, turn over the deed and things like that. Now, counsel has asked for all the liens, and that's contrary to the agreement. The agreement in the title section says landlord agrees to, and this is page 4, accept title to premises subject only to a lien for taxes and assessments. Well,
What section are you in?
I'm on title on page
Title, all
4.
Yeah, we've never inquired. We've been under the assumption that Miss Blair owns this property free and clear. I don't know whether that's true or not. I don't know if she has a note on it that she has to pay. But they are agreeing not to purchase it subject to any other note or lien, so except for taxes.
And Your Honor, I can tell you this. Miss Blair keeps telling me, and I believe her, and I think I may end up filing a motion for reconsideration that she's been paying the taxes, that not Mr. O'Donnell has been paying the property taxes.
Well,
so I think we can get that, we can flesh that out.
All right.
But it won't happen today. And there's also the problem with the option consideration. There's $5,000. That money I don't think should be given to Mr. O'Donnell and Miss Blair at this point in time, because once again, we won't know if they are going to exercise the option. Will they come up with the money? Maybe yes, maybe no. Like you said, they could file bankruptcy. All kinds of things could happen. And so I think that money should be held in escrow perhaps by the court until we know for sure. If they do exercise the option, they get the $5,000. If they don't, then that should go to Miss Blair. So those are the things that they've been talking about with regard to the lease. Now, we really haven't had any evidence of the financial condition of Miss O'Donnell, or Mr. O'Donnell and Miss Bowers. So for them to say, well, we can't do it, and we're not unable to, well, Your Honor, maybe yes, maybe no. We don't have any evidence of where they stand, their profits, loss, and so forth. I do take umbrage with the idea that counsel says, well, they're gonna, Miss Bowers is gonna lose money on her house. Not too many people are losing money on their houses these days, I assure you. I mean, they keep going up and up and up. So if she does sell the house and makes a profit, well, good for her, but that, shouldn't be held against Miss Blair. So I guess, Your Honor, I'd say order specific performance, I think, as you've already adjudged. Order the parties. You can order, you don't have to order Mr. O'Donnell and Miss Blair, Miss Bowers rather, but you can order Miss Blair to follow the language and terms of the agreement. And then let's see where it goes. If she does, if the option is exercised, great.
The problem is, this is gonna take a long time. Miss Blair, this has been a long legal process for you. You've been through 4 lawyers. It's very frustrating. We're not done. Mr. O'Donnell and Miss Bowers, this completely upended your life. Everything was going fine. It was COVID summer 21, but people were outdoors during the summertime. August 4th, you're living in your house, your toes are in the water. 9 days later, somebody comes and tells you have to move out and everything's turned upside down. I don't know what happened between that date and the date that the zoning enforcement officers came. I have speculated about it, but I don't know what happened. Something changed. You had a good relationship with the seller. You'd given her inordinate amounts of cash, which is very unusual. You've given explanations for why it was done. Your banker must have thought you were crazy coming in there every few days asking for stacks of $100 bills. Over 100, over 10,000, they're supposed to report it to the IRS. And at any rate, I do find that they have proven beyond clear and convincing evidence that they gave her $112,000, even for the things that were not photographed. But the 14,000 was photographed. So I believe she got that amount of money. I never understood in the pleadings why there was a contention that she didn't, but that's going to be offset.
All right, guys. Well, there you have it. I am just baffled by this woman's selfishness. I think she knew right from the get-go that these people were suckers, and she knew exactly what she was going to do right from day one. If you look at the lawyer's timeline, it isn't until they ask for the contract to be signed that everything falls apart and all the wacky stuff with the condemnations and the claiming she's not of sound mind starts happening. Because up until then, she was fine with them just dropping off big duffel bags filled with cash every week and having no paper trail tied to it. So my assessment of this whole thing is this couple, they wanted to buy a house. They didn't have any money saved or couldn't find financing from a bank. So, they worked out a handshake deal with this woman to make monthly payments on her house and live in it while doing so. Basically a lease to own. And she read them from square one from the jump for kind of what they were, which were suckers. I hate to say it, but even Judge Middleton kind of acknowledges it. Why would anyone in their right mind buy a house with no contract? Why would you just go to the bank, grab tens of thousands of dollars out in duffel bags and just drop that money up? Like he says, how are you even able to do that? I don't think banks keep that amount of cash. they certainly don't let you take that much out without asking questions. Like, I can't believe that she got away with it for as long as she did. But anyways, like the only certification this guy got that he paid anything was a photo on his iPhone. I mean, we heard it during the and the evidence, but like that was all he like. Thank God he took that though. Beyond his testimony, that was all he had as proof that he made these payments. I mean, the contract thing. I mean, I don't know. With no contract, it's basically his word versus hers, and it kind of was more or less. So she read the mark correctly on them from day one. She figured she could bleed 400 grand out of them in cash, kick him out to the curb, and just claim like, "Oh, they never gave me any money. I'm just an old woman. What do I know?" "Oh, you did? Prove it." And we know that's what her plan was, because it's what she fucking did. Even after the plan went south, she still did that shit. She was claiming till the day that they proved it that they didn't pay her anything. And even Middleton's like, I don't know where that came from. Like, obviously they paid you money. Oh, she's so evil. This lady is like a straight monster. Like, it's so crazy to me. This is the kind of stuff you see in the movies. Wow, she's so committed to the scam. Once they brought her the contract, right, she must have panicked because, like, at that point, she's already committed to it. Like, they've already given her tens of thousands of dollars in cash, and she's thinking it's going to be easy to just get one over on these guys, but now there's, like, actual legal documents on the line, and what she can't just say, like, oh, I can't sign those, I was planning on screwing you guys. So what did she do? She signs it and claims she wasn't of sound mind. I mean, you heard her, like, I wasn't. Get out of here, lady. So conniving. Oh, thank God Middleton was able to step in and put a stop to this, because, god damn. Oh, alright, there you have it, folks. Let me know what you guys thought in the comments. Let me know if my assessment's on point or not. Thanks, by the way, to everybody who left likes and comments on the last few videos. The channel has had some explosive traffic over the past 24 hours, and, like, I have to thank you guys for that, because, like, I don't know, the last few videos were my best performing since I left the Darrell Brooks stuff. I really wasn't sure if I was going to have success on YouTube anymore, like, after this whole Darrell Brooks thing, and it looks like I'm going to be okay, like, and I really have all of you guys to thank for that, and I'm so grateful. Thank you so much. I love each and every one of you guys. I hope you have a great 4th of July weekend. I'm taking the long weekend off, so I'm going on a little bit of a hiatus, but I'll be back next week with more of these Zoom hearings, so it should be a lot of fun. Alright, guys. Thanks again for all the support, and we will see you in the next one, okay? Alright.